All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the Court of Appeals. We have one case on the docket for oral argument today. We'd like to welcome everyone here this morning. And we would call the case of Grange versus Lenoir County. Before we get started, are there any preliminary matters that we need to dispose of? Okay, well, then we will hear from the appellant. Let me introduce the panel. I'm sorry, I didn't do that. To my right is Judge Valerie Zachary. To my left is Judge Julie Flood. My name is John Tyson. This is your panel this morning. And we have our court clerk as well as our court marshal, Deputy Richard Remeliard, that's with us this morning. So we will hear from the appellant.
Thank you, Your Honors. May it please the court, my name is Gabriel Dusablon, and I represent the appellant, the town of LaGrange, in this matter. I would respectfully request to reserve 5 minutes of my time for rebuttal.
Okay.
Your Honors, at its essence, this appeal requires resolution of two issues of ordinance interpretation. The first of which is that whether the Lenoir County Planning Board erred by concluding that Copart's proposed use was auction sales under the zoning ordinance instead of a junk/salvage yard. And the second issue is whether the Lenoir County Planning Board erred by concluding that the junkyard ordinance did not apply to Copart's proposed use of the property. The appellant contends that the answer to both of these questions should have been yes, that the Planning Board's decision was an error for those reasons, and accordingly the trial court's decision upholding the Planning Board's decision was also affected by errors of law. Looking first at the zoning ordinance, the town maintains that both the trial court and the Planning Board erred by concluding that the intended use of the property by Copart was auction sales. Just to recap, the county zoning ordinance sets out 3 zoning districts: rural, commercial, and industrial. The zoning ordinance has a table of permitted uses which sets out the permissible uses of property in each of the 3 districts. Some uses, a small minority of which, are permitted as of right in all 3 zoning districts. Other uses require a special use permit before being allowed in certain districts, and some uses are completely prohibited in certain districts as well. It's also helpful to keep in mind the purpose of the zoning ordinance as stated therein, which is to specifically to regulate the uses of buildings, structures, and land. The term use is also defined to be focused on the purpose for which land, building, or structures are used. The term auction sales is not a defined use by the zoning ordinance, so therefore the plain meaning of that term should prevail. However, we should also apply basic rules of statutory construction to determine the intent of that term.
When the zoning administrator agreed that the application would be approved as under the auction provision, is that correct?
Yes, sir. That was the initial determination by the zoning officer.
And the planning board affirmed that?
Correct.
And on appeal before Judge Pate, that was a certiorari, is that correct?
That is correct.
So she was sitting as an appellate court.
Agreed.
Now, the standard of review that she had and we have is one and the same?
Yes, sir, it is.
So do you agree that as it relates to the planning board's decision, Judge Pate found and we would have to review her decision under the whole record test?
Your Honor, in terms of what the definition of auction sales is, we submit that that is a question of ordinance interpretation subject to the de novo standard of review.
All right, then what would we review under the whole record test? whether there's competent material evidence to support the planning board's findings and conclusions.
Findings and conclusions as to facts, Your Honor, we would submit.
Okay, now, the facts in Judge Pate's order, there are detailed facts as far as the operation of Copart and the duration of vehicles that are on there as related to the typical junkyard, which has a dismantling and a permanent storage aspect that's not present with Copart. Is that correct?
I agree that the judge's order did contain findings to that effect, yes.
And is there evidence to support those findings?
There is.
Okay. Are those findings binding in the absence of any objection thereto?
They're binding if there's substantial evidence in the record to support them. Yes.
So if the planning board's interpretation of the word auction sales, if there's evidence to support the application is compliant with that, and the Superior Court is sitting as a court of review as we are today, how do you, and you did not challenge those, did you?
We do challenge that finding because we believe that's a matter of ordinance interpretation.
Okay, but you do not challenge the fact that the zoning administrator and the planning board both found that the application and uses as proposed by the petitioner were to include an auction sale and did not include the permanent storage of vehicles.
Right, I apologize. I agree that a component of their business was that the vehicles would be auctioned, and so therefore auction sales in that regard, but we disagree that auction sales is the correct use classification for that business.
So how does your interpretation, why is their interpretation wrong?
Your Honor, so for multiple reasons, we would submit that in looking at the entirety of the zoning ordinance and the way in which auction sale is used, there are a number of indications that the county did not intend for auction sales to be so broad as to include any business which utilizes auction as a means of selling its property.
Do you agree with another standard review that zoning regulations are in derogation of free use of property or to be narrowly construed?
I do agree with the principle that zoning regulations are in derogation of property rights and that they are to be strictly construed but that is also a canon of statutory interpretation that is applied alongside the other canons of statutory interpretation as well.
So I'm just trying to understand, you've got the burden to show error.
Yes.
And we've got to presume that Judge Pate's order is correct. So can you show us the error in either her findings or conclusions?
Yes, I believe we can, and that's because we believe that the interpretation of auction sales was in error, and that's something that this court can and should review de novo because it's an interpretation of a term used in the ordinance. So looking at auction sales, there's 141 total uses that are permitted in the table of permitted uses. Only 11 of those are permitted as of right in all 3 zoning districts. 8 of those that are permitted as of right in all zoning districts are associated with delivery of governmental or other essential services such as ambulance services, fire stations, libraries, governmental buildings, animal medical care, churches, and utility lines. The 9th and the 10th are not uses per se. The one is accessory uses, which is just intended to be incidental and subordinate to a principal use. And the 10th is agricultural and farm use, which is subject to the bona fide farms exception in state law. So there's only one left that's permitted use, that's permitted as of right in all 3 districts. And so the question is, what is that? And if you look at the table of permitted uses, there's uses such as banks, pharmacies, convenience stores, but the planning board and the trial court both believe would have this court believe,
You're up, looks like you're upside down, maybe,
I apologize,
on ours.
somehow assuming it had to be oriented towards you, that this use is the 11th use that should be permitted as of right in all zoning districts where convenience stores and banks are not.
So Copart is down here by the expressway?
Yes, ma'am. The rows of vehicles there is Copart's business operation. This is page 63 in the record. And
What are the rows, show me where the rows of vehicles are.
if you can see my pin here,
Right.
these are rows of vehicles that
Okay.
have been parked on a
That's
lot.
exactly what I was asking.
Correct.
Thank you.
And if you'll indulge me, I'll show another image of a Copart facility in the state. And the evidence given at the hearing was that Copart's facilities operate in similar fashion across the state. And so what you would expect to see here is representative of Copart's typical operations.
Well, why would the junkyard ordinance be important to our analysis of the zoning ordinance?
I think because they deal with the exact same subject matter. You have a use under the zoning ordinance that's called junkyard/salvage yard. And then you have in the definition even, the zoning ordinance says all junk/salvage yards must also comply with the junkyard ordinance. So the county, we're not the ones saying, hey, you have to read these together. The county is specifically pointing that out in its zoning ordinance. And additionally, the junkyard ordinance also refers back to the zoning ordinance. It says all junkyards also have to comply with applicable provisions of the zoning ordinance. So these two are meant to be read together expressly stated by the county.
So if there's no dismantling and there's no, I understand junkyard can be things other than vehicles. It can be equipment, machinery, refrigerators, white goods, appliances, things like that as well. So in my mind, the difference is the permanency. A junkyard would have junk that will be there permanently until it's either crushed or sold. Whereas it appears from the plan that they're saying is a lot of these vehicles will be reconstructed or rebuilt. They're not necessarily junk. They're wrecked or disabled, but they are auctioned with the intent that they will be removed and that many of these will be repaired and put back on the service. Or at least that's their argument.
Sure, I don't disagree with that. And I do believe, though, that if you look at the definition used in the junkyard ordinance, it specifically states that the storing, keeping, and selling of wrecked automobiles qualifies as an automobile graveyard regardless for the length of time that vehicles are stored on site. So the plain definition specifically states that the length of time is not material to whether it is a junkyard or not. And
If they were just storing vehicles, let's say that they had a contract with the State Patrol to tow vehicles that were parked on the side of the road for whatever reason, abandoned vehicles, would that be a junkyard if they were storing vehicles that were towed?
Your Honor, I'm not entirely sure. I'd have to look back at the definition under the junkyard ordinance. I believe it does have to be damaged. It is typically expected that they're damaged or inoperable. So if they're inoperable, it could be qualified as a junkyard, yes.
What if they're not all inoperable?
I think common sense has to prevail there. I believe the county made the suggestion in its brief that it would produce the fact that Copart doesn't have only wrecked cars. Some of them are declared salvaged for other purposes. That it means that it's not in the business of keeping and selling wrecked vehicles, but the extremes, I think, should be avoided here in interpreting this ordinance, which is that just having one wrecked vehicle on a used car dealership lot doesn't make it a junkyard, and by the same token, just having one new vehicle or undamaged vehicle on a lot filled with wrecked vehicles also doesn't rule the day. So we think here where Copart has a large number of wrecked vehicles on its lot that it does in fact qualify under that ordinance.
Isn't that the reason we have planning boards and zoning administrators to resolve those conflicts on the matters of degree between one and many? You know, I'm thinking back to the hurricane when we had a lot of flood damaged vehicles, brand new vehicles that were flood damaged. They're not wrecked. A lot of those were sold and put back on the road, even though they had a salvage title. So I think the word salvage is not the same as inoperable or wrecked. So the fact that a vehicle has a salvage title does not necessarily mean it's a junk vehicle. Do you agree with that?
I do agree with that. In common parlance, we wouldn't say that it's necessarily a junk vehicle. But I do submit that looking back again at the junkyard ordinance, that it does include inoperable vehicles and wrecked vehicles. And there's, just because a vehicle is operable does not necessarily mean that it's not wrecked as well. It could be wrecked and still drive under its own power.
Why don't we leave that to the county to determine, you know, if they're going to strictly construe zoning ordinances in favor of the free use of property? Why is it error for them to interpret the ordinance in a way that promotes the free use of property?
I don't believe that it is an error for them to interpret the zoning ordinance, but I do believe that it is an error for them to interpret the zoning ordinance in a way that was not intended by the body that adopted it. In this case, the County Board of Commissioners adopted a zoning ordinance that they intended to govern the use of property in the county, and that if the zoning administrator adopts too strict or narrow of a reading, we believe that that is subject to appeal and review in the nature of certiorari, and that's why we're here today.
Under the whole record test, would you have to show that their decision on their interpretation or the planning board's decision was arbitrary and capricious? Would you have to show that under the whole record test?
If this was a matter that revolved around resolving disputes of fact, then I would agree with Your Honor. But this case revolves
Isn't that
around
exactly what we've got here, is the degree, where do these vehicles fit? Are they salvage vehicles, or are they junk vehicles? Are they going to be put back in the road? Are they there temporarily, or are they there permanently? Does it include things other than vehicles? Isn't that the process that the planning board and the zoning administrator went through when making this decision?
They did, and they did resolve those issues, and they're all part of the facts of the record here before us. But I don't believe we're not arguing a certain view of the facts, and that's opposed by the appellees. There's no real disagreement that what Copart's business operations are, it's how those facts are applied to the defined terms in the zoning ordinance, which is at dispute here, and that, I would submit again, is something that is appropriately reviewed under the de novo standard of review and not the whole records test.
So are you contending then that the Superior Court, do you agree the Superior Court did not err in concluding that the planning board's decision was not arbitrary and capricious?
So that is a question that, so in looking at the case law, it appears that the way that 160D 1402 uses the phrase arbitrary and capricious is if a administrative agency here, like the planning board or the Superior Court, does not rely on substantial and competent and material evidence in the record. And that is what is arbitrary and capricious under that statute. I would submit that it could also be arbitrary and capricious if it was not the product of a reasoned decision or fair and careful consideration, and instead was whimsical. And if the planning board simply said, well, we don't really care what the definition says, we just don't think it's a junkyard, I would submit that that's arbitrary and capricious, but it's not what the statute defines as arbitrary and capricious. So I would submit that there's errors in the planning board's decision that, according to the case law here, would be viewed as an error of law and not arbitrary and capricious.
Was this hearing was public notice and it was open for public comment and public view, right?
Well, it was a quasi,
Judicial
the
hearing.
planning board hearing was a quasi judicial hearing.
Are you complaining about any of the process that was used by Lenoir County during the quasi judicial hearing?
No, Your Honor.
So there's no procedural issue then?
Correct.
So basically, we're down to a matter of statutory interpretation, is that all?
Yes, I believe that's.
Or are we to review the facts in the light most favorable to them?
Your Honor, I believe that this case is a matter of statutory interpretation and that de novo review is appropriate, which means that the court should consider this matter anew and consider the zoning ordinance and the junkyard ordinance in its own right.
If we found the interpretations equally reasonable, yours and theirs, would we overturn the judge's decision just because there may be some inconsistency between the definitions as the parties assert? I guess another way, could we interpret the ordinance to support the trial judges and the planning board's order?
In my honest opinion, that would be in error. We advance the argument that the contrary interpretation is the appropriate one, and I'm not sure if that's what you were asking, Your Honor, but.
But are they mutually exclusive, I guess is what I'm saying? Does it have to be yours or theirs?
I do
And
believe.
if both of them are equally reasonable, haven't you failed to carry your burden to show error in the trial court's order?
So if they're, I don't believe there's really room to say that they're equally reasonable because we're trying to ascertain what the intent of the county was in adopting these ordinances, and so it's either one or the other. I don't believe that it could be both.
We talked about earlier about an automobile dealer having one junk car does not make it a junkyard, and a junkyard having one operational car doesn't make it a car dealer. That was the analogy used earlier. Right. So there is a continuum, right, between one and the other.
Agreed.
And isn't that left to the planning board to make those, to reconcile those facts or to reconcile whatever differences in there?
Well, yes, certainly the planning board was the initial decision maker, but that was subject to appeal and now before this court.
Let me ask you this. I understand that the lake that adjoins this property, from reading the record, that part of your client's objection is that's a water source for the town, correct?
Correct, with the caveat that it's a underground water well. It's not an open body of water.
Okay, and was there evidence as to how any potential contaminants or environmental issues from this operation, how they address those? It seemed to me if they're not dismantling vehicles, I know wrecked vehicles can leak, I'll give you that. But I mean, if they're not doing a dismantling operation where they're removing engines and transmissions and draining fluids, you might not like the use. I can understand that people might not want this next to them. But is the town's concern primarily an environmental use, or they just don't like the fact that this is a vehicle storage facility?
The town's concern was absolutely driven by concern about the environmental impacts of this facility adjacent to its property. Yeah.
Did you show any evidence of their method of operation would cause harm to the adjoining property owners by the way they conduct their business?
We did. There was an expert that we presented, Dr. Richard Spruill, who's an expert in groundwater hydrology, who testified about the impacts that he believed that this facility presented negative and harmful impacts to the town's water supply. But we submit, Your Honor, that that is not at issue here in terms of how polluting they are or anything of that nature, because we're looking at defined terms. And in terms of the junkyard ordinance, those defined terms are clear and not subject to interpretation.
Is this within the city limits of LaGrange?
It is not.
So let me go back. Where's your standing to contest the issue if you're not impacted? I mean, if you're not, this property's not in your city limits, your territorial jurisdiction. Why are we here?
Your Honor, the standing of the town was not contested in this matter, but they're an adjacent landowner and therefore have a interest in the matter under Section 160D 1402, as well as under the junkyard ordinance. Adjacent property owners have standing.
So the town owns the lake?
Yes, it's a piece of property and it is a well. So
Is there a body of water there too?
no, there's not.
Okay, did I misunderstand that from the record?
I believe so, Your Honor. It's an underground water well.
Okay. You had a second issue as far as junkyard, and everyone cites Black's Law dictionaries. I've read the definitions, and some of these terms are defined in the ordinance and some they're not. And if it's a defined term, we're bound by the ordinance definition. If it's not, we use the ordinary plain meaning of that term, correct?
Correct. And you also do look at attempting, if it's not defined, you also apply other canons of statutory interpretation, including harmonizing the remainder of the ordinance and including in para materia other ordinances of the same subject matter. And we would submit too that if you look at the junkyard ordinance, Copart's business operations as a business that still sells and keeps, stores and sells wrecked automobiles is a junkyard, and that a junkyard under the junkyard ordinance is a junkyard under the zoning ordinance, and that the county intended for these to be read together in para materia. And there's another example of why a use of, for example, you mentioned earlier that a salvage yard could include junked appliances or other goods. If you were to accept the narrow reading as advanced by the appellees in this case, that a junk/salvage yard is only a lot that's used to store scrap materials, then a salvage yard that had old appliances or abandoned mobile homes would not fit under that ordinance. But then we would submit, where does it go? And we would also submit that it leads to absurd results to say, where would a facility that stores wrecked automobiles, sells and stores wrecked automobiles go if they didn't sell their vehicles via auction? And the county doesn't really have any I think, compelling answer to that, because they're reading too narrowly the defined terms in the zoning ordinance.
There's a lot of cases that said that the listing of a specific permitted uses does not necessarily exclude other uses, that it's not a comprehensive, exclusive list of things permitted uses, and the way we interpret zoning ordinances narrowly is to encourage the free use of land. How do you want to respond to those line of cases? Basically, that the fact, and this is, auction sales is a permitted use, correct?
Absolutely, and it's a very extremely permissive use, in fact, that it's allowed in anywhere in the county. And we submit that that's something that has to be considered when interpreting it. So as to the land versus Wesley Chapel and Byrd versus Franklin County cases that you're referring to,
right, talked
about prohibited uses, those were applied in cases where a use was completely prohibited outright, and we don't have that here. We're trying to figure out which use designation is appropriate, not trying to prohibit a use outright. And there's another case that addressed the same situation, School Dev versus Town of Wake Forest. There was a dissent in the case that said that the principle of the derogation of property rights ought to compel a different result, a more narrow result, but the majority in that case said that you still have to apply the other rules regarding statutory interpretation to see what the intent of the ordinance was. And we believe that if you comprehensively look at the zoning ordinance, the junkyard ordinance, and look at the inconsistencies that result if you adopt too narrow a view, that the county did intend for a business such as this to be deemed a junkyard under the zoning ordinance and the junkyard ordinance.
You showed us photographs from other locations. Did you do any check to see how those particular sites were zoned in where they have already been established?
How those sites were what, I'm sorry?
How they were zoned and under what basis those other Copart sites were put there? Did you look at that at all?
No, we did not, Your Honor. That would be dictated entirely by the applicable zoning ordinances in those counties.
Okay.
Your Honor, if I may reserve a little time for rebuttal.
Okay, that's fine. Any questions? Any questions? Okay, thank you, sir.
Thank you.
We will hear from the appellee. You will reserve the remaining of your time for rebuttal. You had a few minutes, you had a little over a minute left too.
Good morning, Your Honors. If it may please the court, my name is Keith Anthony, and I represent the respondent appellee Copart of Connecticut in this appeal. I'm going to argue for about 15 minutes, and I'm going to reserve the remainder for Mr. Ferguson, who is representing the co-respondent appellee, Lenoir County.
And who's other counselor at your table, counselor?
This is David Baxter, who is also counsel for Lenoir County.
Okay.
As you consider the town's argument, I think it's important to keep in mind that the planning board upheld the zoning administrator's decision after an exhaustive 8-hour evidentiary hearing. This is not the ordinary length of a hearing of this nature. In fact, it was so long that the court reporter quit halfway through, and there had to be an audio recording for the remainder of it, and then that was transcribed, and all of that is part of the record. So this was a lengthy evidentiary hearing. And following this lengthy evidentiary hearing, in which there was lots of matters discussed, including questions related to environmental impact and everything that Copart does to not act as a junkyard, to address environmental impact and minimize it, from the way the facilities are constructed to their policies that are in place to avoid environmental impact problems. And so following this 8-hour evidentiary hearing, the planning board issued a written decision that's detailed findings of facts, 25 paragraphs, many of which are very lengthy. And as you heard, the town really isn't contesting those findings because there is in fact evidence in the whole record to support it. And that's
Counsel is saying that, it's basically statutory construction.
correct.
And it's de novo review. So they're not really taking any issue with the procedural due process or how the quasi-judicial hearing was conducted.
Right.
So the issue here before us is whether or not which definition we're going to apply to this fact. Let me ask you this. Were you involved in the citing of the other locations?
We were not, no, Your Honor.
So we don't know what the particular zoning ordinances may have been in those other locations he put up.
That's correct. It's not in the record.
Okay. In terms of looking at this de novo, given that there's no issue being taken on the procedural part of what brings us here today, why is it this facility not a junkyard?
Well, because we have to look at what the definition is of a junkyard. We look at the definition of auction sales. And that goes to the point I was making earlier about why it's important.
You agree,
not
auction
challenging.
sales is very broad.
Correct.
That could be furniture, it could be antiques, it could be anything, business equipment.
Right.
And normally auction sales normally you don't have a permanent auction sale. Most of those are site-specific or they're product-specific. Do you agree with that? General acceptance of auction sales?
They can be. They're auction houses that conduct auctions routinely. There's other auction places that are unrelated to Copart. Greensboro Auto Auction in Greensboro is a permanent facility that auctions vehicles. They sell all their vehicles by auction. So yes, generally a lot of auction places are temporary of an estate sale auction, something like that. But we're talking about use of land under the zoning ordinance. So it's talking about using a piece of land permanently or for the foreseeable future for purposes of auction sale. So that's not transitory in its nature. It's the idea, if you're zoning it for this use, is for it to remain in that use.
Going through the record, when you, I think that the vehicle is normally on your client's property for like 60 days.
Up to 60 days,
And
as short as
then
9
at
days.
that point it's sold.
Correct.
When I saw the photograph that he put up of the rows and rows and rows of vehicles, are those vehicles, is there a removal time after the auction is completed?
Yes, so the auction is completed in time for the vehicles to be removed within the 60 days. You know,
Oh,
on average,
it's 60 days total.
correct. The amount of time that they're on the lot, and often it's less. I mean, I think in the record, the evidence is maybe 50 days or shorter, as short as 9 days. So, you know, once the auction is concluded, the buyer has to go pick up the vehicle from the Copart facility. And so it's gone within 50, 60 days.
So those rows and rows of vehicles that he showed us on those aerial photographs, is that just the volume of business that's being turned over within a 60-day period?
That's correct, including, you know, the flood damage vehicles that you identified. It's actually one of the reasons that eastern North Carolina is of interest, because of the flood damage that occurs.
Do you also, does your company or your client also host like tow-ins from like State Patrol on the side of the road, or is your business model more specific to insurance company totals or insurance company
That's
salvage?
correct. That's correct. It's geared towards the insurance companies. They don't offer storage for vehicles that have been towed off the side of the road. That's not part of their model.
Okay, so it's strictly salvage vehicles that have been determined to be salvaged by the insurance companies, either from damage, flood, or whatever reason, right? Recalls?
Repossessed, so not all of them are even salvaged. I mean, there are vehicles that are undamaged, that are in perfectly good condition. They're used vehicles, but they've gone through insurance for some reason or another. The most common for that would be for it's been repossessed or was stolen. Right.
A vehicle stolen and then,
And it's now been determined to be some sort of loss that is getting processed by the insurance company and sold.
so does that differentiate it between a junkyard? Are you advocating that it has to be a permanent facility where these vehicles are brought and dismantled in order to meet the definition of junkyard?
Yes, I mean, so if you look at what the zoning ordinance says for a junkyard, it says the use of more than 600 square feet of any lot for the storage, keeping, or accumulation of material, including scrap metals, waste paper, rags, or other scrap materials, or used building materials, or for the dismantling, demolition, or abandonment of automobiles or other vehicles or machinery or parts thereof. So there's two different situations where it may apply. The first is if you're talking about materials such as scrap metal, waste paper, rags, or other scrap materials or used building materials. That's not here. There's specific findings of fact that say none of those apply. The second situation under the zoning ordinance is that it's used to dismantle, demolish, used to dismantle, demolish, or abandon vehicles, automobiles or other vehicles. And we don't have that. There are no vehicles being dismantled, there are no vehicles being demolished, and there are no vehicles being abandoned. That goes to that permanent nature if it's being abandoned. Here, every vehicle that comes onto the lot is sold, typically, 50 to 60 days. And there, again, specific findings of fact that establish that that situation doesn't apply. So just under the straightforward analysis of here's what a junk/salvage yard is under the zoning ordinance, Copart's intended use does not meet that on its face.
What do you do with defaulted buyers?
Who are going to purchase it and then
Purchasers,
don't
they
purchase it?
don't pick it up.
There's nothing in the record to my knowledge of that, but my assumption would be that it's just resold at the next available auction.
So it could be there longer than 60 days in that event.
Perhaps. There's no evidence in the record to reflect that one way or
But the fact that someone might bid for something and not pay for it, not pick it up, I mean, that's common in any type of business, correct?
I suppose. I don't know what steps Copart takes to ensure that, if there are deposits that are required upfront in order to be able to bid, for example. That does happen in some auction houses, so that may be true here.
How do you respond to the town's parade of horribles in their brief? You know, that if this is allowed, you know, then you'll, you know, be opening the door to commercial kennels and mining and slaughterhouses and, you know, basically anything as long as they operate with an auction.
Well, it's just simply not true. I mean, if you look at the definition for mining, commercial kennels, slaughterhouses, those are all defined terms and talk about what the use is. And all of those, the property is being used intensely to provide some kind of service, or if you're trying to sell something by auction, some kind of product. But to mine, you're going on the property, you're tearing the dirt and land up in order to get a product to extract it. You're talking about then selling that extracted product. If you happen to do it only by auction, then yes, there is sort of a secondary use related to selling a product by auction, but the primary use is the intense use of that property to dig it all up. And so that's a distinction. If you have that kind of scenario and somebody is looking at it between auction sales and a mining operation, the primary use there is a mining operation. That's very different than what Copart has. Copart does have vehicles that are short-term stored on the property, but it's no different than a used car dealership that has inventory on its lot. It's there for purposes of being sold and is then sold. It's brought onto the lot. It's not manufactured on site, which would be more akin to their analogy of, you know, you're mining something and creating a product from the use of the land. These vehicles are brought on site. They're there for purposes of being sold, and then they're sold. The primary use is in auction sales.
Does the title to the vehicle remain with the insurance company?
It is transferred to the buyer upon purchase.
No, I mean, well, until that time, what's Copart's role other than just storing the vehicle and conducting the auction?
I don't believe title passes to Copart. I'm not sure that that's in the record. At least I don't recall a specific cite to the record about that, but I believe it's just transferred directly from insurance company to the buyer.
So typically in a salvage yard, a junkyard, wouldn't the ownership of the vehicle normally pass to the owner or the operator of the yard?
It would. In order for Copart to do what it does, to sell vehicles intact, it's required to have a DMV dealer's license, which is different than what you would see at a junkyard as well.
So do you consider yourself more of an automobile dealer?
Yes. In fact, the planning board found the same. They said we're essentially a used car dealership, except that most of our vehicles have some degree of wreckage, and they're all sold by auctions. Otherwise, the planning board and the Superior Court agreed that we're essentially a used car dealership.
But the town says that your company itself refers to the cars as junk.
There's very little evidence of sort of that context in the record. There were simply some questions that were asked about, has somebody, you know, referred to this as junk? And generally, yes. But if you look at, you know, the information that's in the record, you know, these are valuable assets. There are vehicles that have been sold for over $1 million. This isn't sort of junk as we generally refer to it as. These, in fact, are valuable assets. All of this was contrasted to what's directly across the street from the site of Copart's intended site, and next to this wellhead that the town referred to. Across the street is an actual junkyard, LKQ. It's your typical standard junkyard where things are wrecked, demolished, dismantled, crushed, parts are sold, vehicles are all stacked. You know, the planning board considered all of these factual issues. You know, issues about, is this really junk? That evidence was put before the board, and the board made factual findings. And again, those factual findings aren't contested. The board said this is not junk. This isn't a junkyard in the classical sense of a junkyard. It doesn't have the same kinds of concerns that are present under the junkyard ordinance. It's a separate ordinance that the town keeps trying to conflate because they don't like the definition of a junk salvage yard under the zoning ordinance, so they try to go to the junkyard ordinance. But if you look at the junkyard ordinance, it says, here's the reason why we're adopting this ordinance. There's 6 various purposes, including that these are inherently dangerous properties and use of property, that they're aesthetically displeasing, a variety of things. The planning board, after hearing all of this evidence, said none of those concerns are present here with Copart's use. This inherently dangerous aspect, these aesthetic concerns, none of those are present. And so in that sense, that yes, there may have been some discussion about whether Copart has on occasion referred to this as junk, but not in terms of what matters for this analysis before the court, looking at the application of the junkyard ordinance and the zoning ordinance.
So the cars here are now not stacked,
Correct, they're all
and they're not dismantled.
correct,
So when you sell the car, you're selling the whole unit.
exactly.
So a buyer, even if it's totaled, even if it's crashed, the buyer cannot come in there and just remove what they want and leave the rest.
That's
that-
correct. Yep.
And that's what the record showed?
Exactly. That's what the findings show, and, both by the planning board, by Superior Court, and not contested. Thank you, Your Honors. I'm going to turn it over to Mr. Ferguson for the remainder.
Thank you, sir. Before you step away, any questions? No. Any questions? Okay.
Good morning. May it please the court. My name is Trey Ferguson. I represent Lenoir County in this matter. As the court has already acknowledged, this is a case about statutory construction. The factual findings, the record evidence in this case is not contested, and so it's strictly a matter of statutory construction and how the zoning administrator, the planning board, and then the Superior Court judge interpreted the zoning ordinance. I think it's important on the statutory construction side that this was all done against the backdrop of what Your Honor's already mentioned on the longstanding precedent that zoning is a degradation of common law rights to free property, and so it should be strictly construed in favor of land use, which I believe is exactly what the planning board's analysis was here. And so against that backdrop, we go into the statutory construction of the definitions. There's two.
Let me ask a question here. Is this property privately owned, or is it owned by Lenoir County?
This is privately owned property.
Privately owned property.
So what we've heard and what the town's position is that you look at the zoning definition of junkyard, and then you need to read it in para materia with the definition of a separate junkyard ordinance. And I think the purposes of the two ordinances are important here because they show why the zoning administrator, the planning board, and the Superior Court did not get to the analysis as to the separate junkyard ordinance. And that's because the zoning ordinance regulates the use of property, how it's being used. And then the junkyard ordinance is really regulating the aesthetics. And so I don't think that it's applicable here once the planning board determined that it was not of concern, given the facts in the record. So looking at the junkyard, the junk salvage yard definition within zoning, it's a two-part definition with an or. You have for the storage, keeping, and accumulation of material, or for the dismantling, demolition, or abandonment of automobiles or other vehicles or machinery parts. And then what the town contends is this in bold is what incorporates by reference that all junk salvage yards must also comply with Lenoir County's junkyard and automobile graveyard ordinance. The county contends, and what the planning board, when reviewing it, this reference does not cross-reference and create a cross-reference that takes the separate definition and incorporates it. It's simply saying that it's a junkyard under zoning, then it must comply with the aesthetic regulations found within the separate junkyard ordinance.
Under the first definition for the storage, keeping, or accumulation of material. You don't disagree that that's what Copart does?
Well, I do disagree. I disagree that the definition with material, which is not defined here, if you give it its plain meaning, as well as use the associative canon of ne sequitur associus, looking at the list that follows as examples, it's material that are similar to nature of scrap metals, waste paper, rags, or other scrap materials or used building materials. It's materials that have been used, are discarded, and left permanently, I think is how material is defined based on the company that it keeps. I also think that when you have a two-part definition, the statutory canon of construction, that the more specific provision will prevail over the general. Here, we have a specific portion of the definition that applies to automobiles, which is the dismantling, demolition, or abandonment of automobiles or other vehicles or machinery or parts.
Well, when you have the disjunctive or instead of and, under statutory construction, either one standing alone could meet the definition. You do agree with that?
Yes, I agree with that.
So the fact that it's not and, the fact it says or, either definition standing alone could implicate the ordinance.
Yes, Your Honor, I agree with that.
Now, when you're followed by the subjective description, scrap metals, waste paper, rags, or other scrap material, or used building materials, that's a list that's examples. And is your argument is Copart's operation is not like that list?
Yes, I believe the planning board in making the determination that it didn't follow under junkyard was that Copart was temporarily storing these vehicles to be sold at auction. The vehicles are not material that are similar in kind to scrap metals, waste paper, rags, or other scrap materials, because the vehicles are not being discarded there. They're being temporarily stored there and then removed after an auction.
So is there something in here that requires a permanent as opposed to a temporary storage or a permanent placing?
No, I don't think, based on the plain text of this, that there's a requirement of permanency. I do think that based on the examples that follows material, that those types of examples allude to the intent of that definition, which was discarded pieces of material that are left there.
So, but there's nothing in this definition that would require a permanent abandonment or storage in order to trigger the ordinance. You agree with that?
Yeah, I agree there's nothing in the text that requires a permanency. I do think that under a canon of statutory construction, if you have a specific provision of the definition that applies, that would govern over general, but I do agree with that.
On the second definition, or the dismantling, demolition, or abandonment of automobiles, is that what you're referring to?
Yes, Your Honor.
Or other vehicles?
Yeah, I think by referencing that there are vehicles and there's a portion of the definition that includes vehicles, that when the county adopted this definition of junk salvage yard within zoning, they were referring to a junkyard is a use of property that demos, abandons, or dismantles automobiles if they're storing these vehicles. And that's not what's happening. The record evidence shows that that's not what's happening with Copart's facility. They're temporarily storing them until they're sold at auction.
And when they're sold, the entire unit is sold?
That's correct. That was what was
Not pieces
presented.
and parts?
I'm sorry?
Not pieces and parts?
Correct. I also think when you look, and I think we cited in the brief, that the plain language of material refers to parts of a whole, and in this situation, the cars are being, sold and stored intact as a whole, and then transported away from the site after an auction, and so they're not parts of the vehicle.
If you go under either definition, and there's no requirement of a permanent storage or permanent abandonment, then it would also trigger, the fact that it's a temporary does not take it outside the junkyard ordinance, I guess is what I'm saying, right?
I'm sorry, could you repeat?
The fact that the vehicles are stored temporarily and not permanently, that's not disqualifying that it's a junkyard.
I don't think it necessarily disqualifies it from a junkyard under zoning definition. I do think it disqualifies it as a junkyard under the separate junkyard ordinance, which has a different definition of junkyard. And so this is the separate junkyard ordinance's definition that specifically talks about, again, two-part, maintenance or operation of an automobile graveyard. And then when you look at the definition of automobile graveyard, storing, keeping, buying, selling, wrecked, scrapped, ruined, dismantled, or inoperable vehicles which are not being restored to operation. So specifically contemplating that vehicles will be restored. Now, in this situation, they're not being restored on site, they're being sold intact, and most of them are being restored by an end user or for an end user. And so I think that's what disqualifies it, especially given the fact that when you look at the incorporation of automobile graveyard under that separate junkyard ordinance, this contemplates this is where cars go to die. That's what a graveyard is that they're going to go there and die, and that's their final resting place. And that's not what's happening here. You have cars coming in temporarily and then leaving the site after an auction, which is why I think it disqualifies definitionally under the separate junkyard ordinance that regulates the aesthetics of the use.
So just to restate, I think this has already been stipulated to, this was not a rezoning case at all.
Correct.
This was a permit to use, this was a use permit, correct?
Correct.
And does the ordinance require a application even on a permitted use?
I'd have to look back at that, and I don't recall offhand if it requires an application.
Well, I guess if I've got a piece of property that's already zoned for permitted use, I guess I'd have to get a building permit, or I would have to comply with the building ordinances, but do I even need a zoning permit?
I think that it was, and I'll defer to Copart's counsel if I'm incorrect here, but I think the understanding was before moving forward with, some of the development, they asked for, in part of the diligence, whether this complies, whether this can be a use.
So,
Copart didn't purchase the property until it got that determination by the zoning administrator.
but you would generally agree that if you've got a permitted use of right, no rezoning is involved, then what you're getting is a letter from basically what you were seeking was a letter from the zoning administrator that this is a permitted use on this property within the zoning?
Correct, that this intended use qualifies as an auction sales and is a permitted use, so no further approvals are required.
Okay, thank you.
So again, it's the county's position based on the zoning administrator's interpretation, planning board, and Superior Court's interpretation, that Copart's use as presented in the application and then the record evidence at the 8-hour hearing was that Copart's intended use was not going to be a junkyard under zoning, and that it didn't implicate that separate junkyard ordinance. And so the next step in the analysis, if it's not a junkyard, what use is it? And again, this court, in longstanding precedent, the Supreme Court, Yancey v. Heffernan, says that zoning regulations cannot include or exclude by implication. And so if you have a use that's a close call, that we don't know if it fits in this table of permitted uses, it cannot be excluded just because it's not listed. Because it's impossible for a municipality to list every possible use a landowner can use for their private property. And so if it's not a junkyard, which is not permitted, if it's not a junkyard, the next step is, what is it? And the land case, which cited in the brief extensively, stands for the proposition that you analogize it to the closest permitted use. In this case, the zoning administrator saw that the cars were being auctioned online, and so he said they were auction sales. He very well could have looked and said that they were automobile sales as another permitted use, and I think under a de novo standard, if you find that there's another permitted use that is more analogous, that you could say, well, it might not be auction sales, but it is one of these other permitted uses. But again, the land case stands for that proposition that if it's not expressly excluded, that you err on the side of free use of private property, because zoning is a derogation of common law rights. And that is what the planning board, the zoning administrator and the planning board did in their analysis.
Is automobile sales a permitted use under this specific ordinance,
Yes.
under this use?
Yes, Your Honor.
So not only is auction sales permitted, automobile sales are permitted, correct?
Yes, Your Honor. Now we can pull up the. And the commercial district is the middle column.
So automobile and small truck sales, new and used, the P means permitted, correct?
Yes, Your Honor. And this is provided in the record.
Give a page number for this.
I believe it's either page 117 or 118.
So the S would indicate a special use?
Yes, in which a special use permit would be required. And if you don't have any other questions, thank you.
What would you have the court do?
I would have the court uphold the Superior Court as well as the Planning Board that Copart's intended use is not a junkyard, but rather is an otherwise permitted use, and so there is no error. And I would just add, because it was brought up, I don't think this is contested procedurally, but from the point that the town's brought up, the arbitrary and capricious issue, I think that the record evidence shows that after an 8-hour evidentiary hearing in which they considered all of the evidence, all of the testimony, and came to this conclusion, the fact that it's a complex legal analysis that requires the Court of Appeals to have oral arguments, I don't think it can be considered arbitrary and capricious finding. I think if it's a close call and you decide to go on the side of the town, that it's not arbitrary, it was a reasonable misunderstanding or misapplication, but I do not think that's the case. I think that the way the zoning administrator as well as the planning board interpreted the zoning ordinance effectuated the intent and said it was a permitted use.
Thank you, sir.
Thank you.
Rebuttal? You have about 6 minutes and 20 seconds.
Okay,
So you have your original 5 reserved plus another minute 20.
Oh, I apologize. I misconstrued that. I thought I was very pressed for time. Thank you, Your Honors. So I did want to look quickly at a couple of the definitions that were gone over by opposing counsel in this.
Let me ask you this while you're getting that on definitions. Automobile sales, new and used, is also a permitted use. So even if we were to agree with you that this is something more than an auction sale, how do you refute the fact that automobiles, new and used, is also permitted as well?
Sure, absolutely. I'm glad you asked that because it was something I did want to look at. If you look at the table of permitted uses for automobile sales, new and used, first I would note that a new car dealership, as this would be, is already more restrictive than the auction sales use classification that the zoning official in this case thought was appropriate. So that appears to be inconsistent with the idea that even new cars require a special use permit in the rural zoning district.
Yeah, but we're dealing with a commercial district, right?
I understand that, but in talking about looking at the entirety of the zoning ordinance, it suggests that the county did intend for auction sales to be viewed more restrictively than new car sales. And so the idea that you could sell wrecked cars and locate in a rural district, I believe, is an illogical result.
Well, could we also say that that automobile sales in rural areas require a special use permit as opposed to auction sales being permitted, but in commercial district they were treated the same as permitted uses?
Yes, no doubt. If you're talking about a specific.
So the rural district, the special use permit being required for automobile sales, that does not really say that, what to me is saying that automobile sales in residential areas do require a special use permit, but auction sales do not.
Yes, exactly that.
Okay.
And then I would even point to the use classification directly above that as another example of ascertaining the intent of the county here, where automobile and small truck repair and/or body work receives the exact same treatment as new and used auto sales, which is that they're permitted in the two heavier districts, but require a special use permit in the rural district.
But it's also a permitted use in the commercial district.
Agreed.
So if you think there's any type of repair or body work, which I understand there's no testimony to show that anything are done to these vehicles while on site other than storage, correct?
Right, I'm not contesting.
There's no
that.
repairs or painting or anything like that.
Right. Agreed. They're selling them in their current state, but I would point to the parentheses under that use, which indicates that it specifically excludes storage of junk vehicles in that use classification. And again, this is a use that requires a special use permit in the rural district, is permitted in the commercial district, but does not include storage of junk vehicles. And we would submit that that shows that the county intended a more restrictive use for storage of junk vehicles. I want to go back briefly and address a issue that Your Honor asked of opposing counsel about the automobile graveyard and the permanency of the vehicles. And he did put up the definition of automobile graveyard, but the part that's not highlighted was directly on point to Your Honor's question, where it states that the definition applies regardless of the length of time which individual motor vehicles are stored or kept. So permanency does not matter in terms of the junkyard ordinance. And if you look back again at the definition of junk, this includes the same sort of materials that the county was saying, that the junkyard under the zoning ordinance includes, but it does include wrecked automobiles here. We submit that the county was simply trying to be effective in its zoning ordinance and not repeat the entire definition, but say, look, go look at the junkyard ordinance. We have a junkyard use, and then we have a junkyard ordinance that you have to comply with. And these are meant to be read together, where junk, including, for example, broken appliances or parts thereof, or manufactured housing units, are also considered junk, also considered a junkyard if they're being kept on a site. And again, if you read the term junkyard under the zoning ordinance so narrowly as the county has to be just scrap materials, there's no place to put a scrap yard that has broken appliances on it, because those aren't materials. Abandoned manufactured homes, because those are not materials. So we submit that junk is defined to include all the things here, which includes wrecked automobiles. And the fact that they might have value, it might be a wrecked Ferrari, doesn't alter the fact it still fits within this definition. This is not like a used car dealership. We believe that the fact that the vehicles are wrecked is quite a bit different than a used car dealership. One of the points that was made by the attorney for Copart was that the distinction, the parade of terribles that the town raised does not lead to absurd results, because in those cases, it's the intense use of property that produces the product being sold. First would submit that that's not the case in terms of like a slaughterhouse where you're bringing animals on the site and then you would be selling those products. But also, I think it's difficult to conceive how the use of property that Copart intends here is not intensive use of property, that they're parking thousands of wrecked cars on this property, that...
Well, now, in all fairness, they're not all wrecked, are they?
They are not all wrecked. I agree that the evidence does not show that they are all wrecked, but at least half, and I believe Council for Copart said most, are there because they're wrecked. And The photos and the evidence also show some having significant damage, being totaled, rollovers, and so this is not like a used car dealership.
Do you agree that there's no evidence to show that any of these vehicles are dismantled or worked on here, that they are brought in and then they go out in the same condition they're brought in?
I do agree with that,
And they're sold as a unit and not for parts?
I do agree with that, and I think that actually does go to a point that the county said, where they said that they're not being restored to operation, and, Your Honor, am I out of time? I see it.
You got about 20 seconds left.
Okay. They're not being restored to operation on site, and I believe that that's not a fair reading of what that definition is intending there. It's intending to exclude businesses which operate to bring wrecked vehicles on site and repair them on site. And that's the intent of the restored section.
I'll give you a moment to sum up.
Thank you, Your Honor. We believe that if you look at these two ordinances together, reading them together as we believe the county intended, that the planning board's decision should be reversed, that the proposed use be considered a junk salvage yard under the zoning ordinance and a junkyard under the junkyard ordinance, and that those two are both issues before this court that need to be resolved. Thank you, Your Honor.
No.
Thank you.
Thank you very much. The case is submitted. We appreciate President's Day. Counselor, would you also introduce your co-counsel that's at your table as well?
Oh, yes, sir. I have Jim Collie here with me today.
Thank you. Thank you very much. All right, we adjourn court.
All rise. You're welcome. This session of the North Carolina Court of Appeals is adjourned.